First of all, good evening, everyone. I'm excited to be here this evening with Harris Bricken and the Queen's Defenders to discuss marijuana licensing and selling and expungement laws in New York State. Thank you both for partnering with the Borough President's Office today, and thank you for all the work and partnership you've done with us, not only in my role as Borough President, but subsequently during my time in the City Council. For those of you who don't know who Harris Bricken is, they have a long history of providing legal planning and regulatory support to cannabis businesses. Their commitment to exceptional work has made them a leading name in the industry. Queen's Defenders, who I've had the luxury of working with as well, has over 450,000 individuals in criminal cases since 1996. It served over 450,000 individuals since 1996. They are dedicated to connecting their clients to resources and providing prevention mentoring programs for youth and to reduce the impact of criminal records on employment, housing, education, and public benefits. And I am always proud of the work we did in creating the youth court in Far Rockaway, which was the first of its kind. I'd like to also thank the community organizations that have joined us today for their reentry work with those impacted by the criminal justice system. Today, we are here to discuss the Marijuana Regulation and Taxation Act, a new law that will change the landscape of the New York economy and put the state on a path to restorative justice. For far too long, marijuana has been a barrier to employment, housing, and education for individuals and communities already suffering from inequality. And I will go back to my time in the council as the public safety chairman, certainly uncovering that 86% of all arrests and summonses for marijuana were comprised of people who were Black and brown. And we know that Southeast Queens in particular at that time had the highest amount of arrests and summonses in New York City for over a decade. And I'm proud of the work we did in passing legislation in the council. I led legislation that mandates now every precinct in the city of New York to report on their marijuana summonses and arrests. And because the NYPD is mandated to be more transparent here, we went from somewhere around 20,000 arrests and summonses down to, I think before I left the council, somewhere in the ballpark of 400, which we were still not happy about the disparities, even in those numbers. But we know that's why we're here to talk about legalization and expungement. And also the other thing is, even as we see this industry emerging in New York State, we want to make sure that our communities are not simply being targeted for contact, but we want some contracts. So today is a very important conversation. These justice impacted communities will benefit from the emerging economy. The Queensborough President's Office is committed to reducing the disparate impact of previous drug laws by ensuring those communities that once again were hit the hardest are the first in line to get licenses for legalized adult use marijuana distribution. Additionally, sealing and expungement will break barriers, provide new opportunities, and put an end to punishing people for crimes long after they have served their sentence. And let me just say, this was a very important part of the state legislation, and I'm very proud of all of the advocacy groups and elected officials who stood firm on making sure that this was a part of that package. Tonight, you will hear more about opportunities to gain a license under the Marijuana Taxation and Regulation Act and how criminal records should be sealed and expunged under the law. We have seen the success of those in other states who have opened their marijuana markets well, and we have heard the stories of those who have had their records sealed. This process, once again, can be life-changing. Please take this opportunity to ask questions and reach out to my office with any additional concerns. And I can tell you, we're going to be in this for the long haul and ensuring that, once again, communities in Queens, especially the ones hit hardest in the drug war over marijuana, are the ones who are going to be the ones who reap the biggest benefits. We don't want to see this industry gentrified and other folks who were not harmed as much taking the lead on this. So with that being said, I'm going to turn it over to Tarika Morrison and both Catherine Breslin. I want to thank them both for the work that they've done. I also want to thank Tiffany Eason and Chris Barker and Aldo, who will be ensuring that this program runs smooth virtually. But once again, please stay in touch with our office, and we are looking forward to future discussions on this. With that being said, our leader and director of intergovernmental affairs, and Kat, will take over this. Thank you. Tarika, take it.
Thank you, BP. Good evening, everyone. I'm Tarika Morrison, Director of Intergovernmental Affairs for the Queensborough President. And tonight I will introduce our esteemed panelists. First, we have Simone Malinowski from Harris Bricken. He is the managing attorney for Harris Bricken's New York office, where he helps clients navigate the real estate and cannabis markets. Simone is experienced in navigating newly enacted cannabis legislation, combined with his finance and real estate expertise, provides his clients with significant advantages in New York's developing cannabis market. He is also a regular contributor to the award-winning Canna Law blog. In addition, for 5 consecutive years, Simone has been named a rising star by Super Lawyers. We also have Carolyn Joseph. She is an attorney and the director of special projects at the Queens Defenders. Carolyn grew up in Jamaica, Queens, and has an extensive history representing youth and adults in the criminal and juvenile justice system. Thank you both. And with that being said, I will turn it over to you, Simone.
Simone, if you can hear me, please unmute your mic.
Hi, can you hear me okay now?
Yes.
Okay, 2 years into the pandemic and we're all still trying to figure out virtual meetings. Thank you all for the very warm introductions. Again, my name is Simone Malinowski. I'm the managing attorney for Harris Bricken's New York office. And today I'm going to be talking about the Marijuana Regulation and Taxation Act. We'll go over some of its history, how we got to where we are, the various license types, which I think are one of the things that a lot of people and prospective clients that we talk to are interested in learning about. We're also going to talk a little bit about what the license application process looks like as we know it now. And we are still waiting to learn more information about the specifics of the process, but that's another kind of topic that we'll cover. And then I want to spend a little bit of time talking about the social and economic equity program that's included as part of the MRTA, as well as the Social and Economic Equity Fund that was recently announced by Chairperson Tremaine Wright from the Cannabis Control Board. So to give all of our participants a little bit of background in terms of how we got to where we are today. For the last few years, before March of 2021, New York had been in the process of trying to pass adult use or recreational cannabis legislation. A few years before that, we had successfully passed a medical cannabis program, which was one of the more restrictive cannabis programs in the country in terms of allowing patient access. But for a number of years, the state legislature really tried to get comprehensive cannabis legislation passed for recreational cannabis. And in March of 2021, there was a breakthrough. And there are a number of reasons why it happened this year. A large part of it did have to do with the COVID-19 pandemic and its impact on our state's economy. But ultimately, in March of 2021, we were able to push through the Marijuana Regulation and Taxation Act, which was signed into law by then Governor Cuomo in April of 2021, which is what started this process. Now, it's kind of one of the dry parts of this, but I do think it's important to talk about, which is kind of the process for one, the rules and regulations that will ultimately be how people submit applications, and then kind of a quick update on where we are now. Now, the recreational cannabis industry in New York didn't exist before the MRTA was passed, or at least the legal recreational cannabis industry. And to build an industry from scratch requires a lot of legislation, and then a regulatory body, and basically an entity that's responsible for setting up the industry. And what the MRTA did was it created two separate kind of governing bodies. One was the Cannabis Control Board, which is responsible for drafting the rules and regulations that will actually implement the MRTA. And then there's the Office of Cannabis Management, which is kind of the equivalent of the state liquor authority. It's actually the Office of Cannabis Management is within the state liquor authority, and they're responsible for administering the rules and regulations, actually issuing licenses, and the kind of practical things that we all think of when it comes to submitting applications to a governing body. And so it took a little bit of time in order for the Cannabis Control Board to actually be formed, for the members to be appointed. The same is true for the Office of Cannabis Management. In fact, just today, the Cannabis Control Board had another one of its meetings. I think it's the 5th or 6th since the MRTA has been passed. And they are still in the process of kind of staffing up and getting to the point where they're ready to release the rules and regulations that will be the substance of the application process and really push things forward. So with all of that said, and I know that's probably a lot to take in at once, I wanted to first go over the different license types, and I'll kind of go with the technical names first and then break it down a little bit for the people who aren't as familiar with we'll call industry lingo. But New York, unlike many other states, has decided to do things in a different way. And the way that we are doing it is there's a general ban on what's known as vertical integration. And what that means is that when people apply for and ultimately obtain licenses in New York, they'll be restricted to only being able to obtain one specific license type. Now, the reason for that is the cannabis process itself has various different components, from growing to processing the grown product to ultimately selling the product, which is the retail side of it. There's kind of the chain in between those 2 points, which is the distribution. And in many other states, what happens is that you're allowed to obtain a license that goes throughout the entire production chain. That's called vertical integration. And in doing that, what has happened in a lot of other states is that there are a few larger players who get into the industry early and are able to kind of monopolize the industry from different perspectives. In New York, the legislature was really, really keyed in on giving as many people an opportunity as possible to get into the industry. And so what they've done is that they've limited the number, each applicant to only be able to obtain one specific type of license. So the license types themselves, there is a cultivator license, which is, for lack of a better term, the growers. They're going to be the people who are responsible for, in grow houses, growing product from the ground up or hydroponically. There will be a processor license, which is the people who take a grown product, so the flower, and then convert it either to an edible or some other a different type of product that can be used, tinctures, various types of oils for vaporizers. The next license type is a distributor license, and they are responsible for being the middlemen between cultivators and processors. And then the next license type, which is retail dispensaries, and on-site consumption, which is two separate and distinct license types, which are both interesting, and we're still waiting to see the interplay between the two of them. But retail dispensaries are kind of exactly what they sound like. They're going to be your local stores where you can, if you're 21 or older, go in and purchase cannabis products. On-site consumption is a little bit different. On-site consumption licensees are going to be locations where you can go in and publicly consume cannabis products. We don't know exactly what that's going to look like yet. We're waiting to see how the rules and regulations really break down what you're allowed to do and what the interplay between those two license types are. For example, whether or not you'll be able to sell product in an on-site consumption lounge, which obviously would make sense, but we're still waiting to see those specifics. There are several other kind of slightly different license types. There's going to be a delivery license type, which is limited to 25 employees, but they are going to be licensed to just kind of take product from retail dispensaries and deliver them to individuals 21 or older. There's going to be what's known as a micro business license, which does actually allow for being involved in the entire production cycle. But the kind of caveat there is that we're still waiting to see what the definition is of a micro business. There's going to be a nursery license, which has to do with actually cultivating young versions of plants and being able to sell them. There's going to be a testing license, and I think that covers all of the adult use licenses. There's going to be some, yes.
May I just interject, because there's a question that is with regard to the cultivation, and I'm not quite sure how to answer it in the chat.
Sure.
It says, is there any information about being able to start a cultivation business at your residence to lower the initial startup cost and getting some income flowing to future expansion? I was hoping you could address that.
So it's a very good question. So as of right now, we don't know the specific answer to that. And the next kind of topic that we're going to talk about is what the license process looks like right now. And it's a very good segue. We don't know what the specific rules and regulations will be in terms of kind of, we'll call it a home cultivation business. Part of the issue there, and this is something that we come across really often when talking to cannabis clients, is zoning, right? Because in commercially growing cannabis products in your home, you probably are going to run into some pretty serious issues if you're leasing with your landlord, if you own it and you have a mortgage with your lender. And so, on one hand, we'll need to see what the rules and regulations say. On the other hand, it's the sort of thing where anytime you're running a business out of your home, it's something that you have to be really careful about. And when you're contemplating running a business where you are violating federal law, because technically speaking, cannabis is still a controlled substance, you really have to be careful with it. So for anyone, and I don't know who asked the question specifically, but if you're considering starting a cultivation business in your own home, I strongly suggest, one, waiting until the rules and regs come out before starting operations, and then two, talking to an attorney before you really dive in. So
also, I'm sorry, I just wanted to add additionally, you are allowed to grow at your home and gift at this point. Do you want to speak to that?
So you are going to be allowed to grow at your home. They have not yet allowed home cultivation of plants for adult use purposes. That's going to be something that is, it is included in the MRTA, but the express permission to do that and the rules and regulations that govern that have not been released. To that point, It's one of the things that was expanded for medical patients, but medical patients and adult use are two separate and distinct things. So I do want to, there is information out there that the number of plants that you're allowed to grow at home has increased. That is separate and distinct. That is part of the medical program and not the adult use program. So all of that said, this is a very good segue to the license application process. And the application process right now is a little bit murky. We have kind of the broad rules and the things that we know will be a part of it, but the kind of nitty gritty details that most people hate and us attorneys love, those haven't been released yet. And that's part of what we're waiting for from the Cannabis Control Board and the Office of Cannabis Management. So a couple of big things that we do know at this point. You're going to have to be very upfront and transparent about your application process. You're going to have to identify which license type you're applying for. You're going to have to disclose not only all of your identity, but your racial and ethnic diversity, the information about all investors or partners that you have, if you have any, if you are applying as a company or a corporation, which is something that we typically recommend. The Office of Cannabis Management is really going to drill down on your corporate structure. You're going to have to demonstrate evidence of good moral character, which is kind of proving a negative, but they will be looking at criminal backgrounds. And, one of the things that we will talk about, and the Queen's defenders will talk about when it comes to expungement is that cannabis convictions are something that are going to be expunged as part, or have been expunged as part of the MRTA. There are crimes of kind of bad character, fraud, theft, those sorts of things are going to be major issues when applying, and something that will come up as part of criminal background checks. Another major thing that they're going to look at are your financial statements and whether or not you're kind of financially equipped or have backing for undertaking this venture. And part of that is having your real estate secured at the time of applying. And for a lot of people, that's a real consideration. And when we get to talking about kind of the things that we advise people to start looking at and thinking about now, real estate is a huge part of that. Now, there's a slight caveat which has to do with social and economic equity applicants, but it is really important to note that for non-social and economic equity applicants, owning or leasing your real estate at the time that you apply for a license is required, which means that where you intend to operate is something that you really need to start thinking about now. Now, another big question that we get on a regular basis is whether or not there's going to be a specific license fee as part of applying. And the answer is that we assume that there will be, but until the rules and regulations come out, we won't know specifically what the license fee will be. We expect that it will be staggered based on the different license types, but we're still waiting for those specifics. Selection criteria. So let's say you get your entire application put together, you have all of this information, and you kind of want to know what your odds are in terms of actually getting your license approved. The MRTA kind of really specifically goes through what they are going to be looking at, or the Office of Cannabis Management and Cannabis Control Board are going to be looking at when evaluating license types. And there are a number of things that are in there. The first is whether or not an applicant is a social and economic equity applicant. Again, we'll talk about that after we get through the application process. being able to demonstrate that you are prepared to operate this business is really important. And what being prepared means is a number of things. That you have a system in place for security, that you have a compliance system in place to make sure that your employees are adhering to the laws and making sure that only people who are 21 and older are able to purchase product, to making sure that there is a tracking system that's in place that ensures that your product is being, what you're selling or cultivating is being tracked throughout the production chain. Because one of the things that's really one of the key goals of the MRTA, and really early on after it was passed, one of the sponsors of the legislation, Crystal Peoples-Stokes, gave a speech where she said something that I thought was really important and really great to hear, which is that this legislation was passed for New Yorkers to benefit New Yorkers. And one of the things that is built into the way that the law works that is part of that is that every single part of the production cycle must come from New York. The product must be grown in New York, it must be processed in New York, and it can only be sold in New York. And that's the sort of thing that's inclusive in a way that really benefits the citizens of New York, that I think is really important, and something that they're going to be looking at when evaluating license applications. Now, there are the social and economic equity applicants. Even for non-social and economic equity applicants, the MRTA really puts an emphasis on everyone benefiting the communities that have been disproportionately impacted by the enforcement of cannabis laws. And so what that means is that even if you don't qualify as a social and economic equity applicant, as part of your application, one of the things that is going to be evaluated is whether or not you can demonstrate that you have a plan for benefiting the communities and people who've been impacted by cannabis enforcement. And that means employment opportunities, that means partnerships with local and grassroots organizations that benefit those communities. But they are really going to be looking at applications from a holistic perspective in terms of how you are benefiting the communities in which, one, you're operating, and two, that have been historically impacted. There are a few other kind of more technical points. Once we get done, I'll talk about our blog, and there are links that we can publish, and maybe Kat, we can post it in the chat. But we really do meticulously go through both the license types and the process for applying. And so I think for people who are really interested in the line by line analysis of what's going to be considered, it's a great resource just to get information on what we know now based on the MRTA. Now, at this point, I want to transition to this social and economic equity program and related fund. And this is really one of the central motivators for passing the MRTA. And I think that it's hard to undersell how important this program is and how seriously New York is treating social and economic equity. So the broad strokes are this: there is going to be a social and economic equity program that allows for certain individuals to get priority from a licensing perspective. And there are a few categories. It's individuals from communities disproportionately impacted by the enforcement of cannabis laws, minority-owned businesses, women-owned businesses, distressed farmers, and service-disabled veterans. There's actually currently a couple of pieces of legislation that are pending on the state level to expand the definition, one by Senator Jeremy Cooney. That legislation hasn't passed yet, but the equity plan, one, allows for priority for those applicants, and the MRTA expressly states that there's going to be a target of 50% of licenses awarded to social equity applicants, which is a tremendous goal. I think it's the sort of thing where we can finally start to reverse the really significant, horrific wrongs that have been really caused to the communities that have been targeted by cannabis enforcement over the years. And so far, it really does appear as though New York is taking the social and economic equity program seriously, because it's something that has been enacted in a number of different states, but not always with success. Now, when we talk about the things that have been done and that appear like as though they're going to happen that benefit social and economic equity applicants, one of them is that there are some slight differences in the application process. One of which is that, and we're waiting to see how this plays out in the rules and regs, but that you will not necessarily need to have your real estate secured at the time of application, but you would need to just have a plan demonstrating how you're going to go about obtaining real estate. And for anyone who's ever been involved in business, particularly in New York, real estate is a huge and significant overhead cost. And so not having to secure that real estate prior to applying is huge. The bigger thing is that the MRTA contemplates the creation of funding programs as well as incubator programs for social and economic equity applicants. And for a while, we didn't really know what that meant. But very recently, Tremaine Wright of the Cannabis Control Board announced that New York is creating a $200 million social equity fund, which is going to be used to assist with social and economic equity applicants, pay for the costs of applying for and obtaining a license. And again, I know I kind of am repeating myself. We're waiting to see the specifics on this, but as of now, it appears as though that the money is going to be allocated specifically for retail and on-site consumption applicants, and with an emphasis on real estate acquisition. How that's going to be funded is another issue that's up in the air. The statements that have been made that it's going to be a combination of license fees obtained from non-social economic and social and economic equity applicants, as well as from private funds. We at the Canna Law blog think that it's incredibly important that the funding come from non-license fee sources, in large part because I think it's very important that equity applicants start on the same foot as everyone else. And if the funding is contingent on license fees obtained from non-equity applicants, that by definition means that we're going to be waiting for equity applicants to start applying after other applicants, which is problematic for any number of reasons, which we can get into in the Q&A portion of this. The last bit that I wanted to talk about before handing it over to the Queen's Defenders and the Q&A portion of this is where we stand now, because I know that one of the things that you have all heard me say, like a broken record over and over again, is that we're waiting to see what the rules and regulations say. As of now, we are hopeful that we get to see the rules and regulations in their initial form at some point in the first 3 months of 2022. It is entirely possible that it will be a little bit longer than that, which is understandable given the fact that we are creating an industry from scratch. But we are hopeful that the first draft is released in the next few months, at which point the rules and regulations will be open for public comment. The public comment period is something that's part of the MRTA. And then after that, the final rules and regulations will be issued. And we will get to see what window there is between submitting applications and then the ultimate license process. So that really is kind of the 10,000-foot overview of where we stand now. I know that that was a ton of information at once, and that there are a lot of really nitty-gritty specifics of this, how the different license types interplay with each other. We can save the specific questions for the Q&A unless, Kat, there's anything that has popped up now.
There is quite a bit that's popped up, and while I do really want to move over into the segment for the Queen's Defenders, I want to address some of this.
Sure.
There are questions around social equity, but let's first focus on our resources like SBA and SBS, informed about these licenses and how to help small business owners to start the application process.
So this is a really tricky area because the SBA is federally funded. And federally funded loans are not eligible for cannabis businesses because cannabis remains federally illegal. And this is actually, I know it's a slight divergence, but something that I do think is important to note, which is that any part of contracting with a business, be it a landlord or a bank that is federally insured or somehow beholden to the federal government via contract, cannot engage in business with cannabis businesses. And most of the time it will be expressly written into whatever the documents are. And so banking is a really good example of this. The people in the industry are really familiar with this problem, but cannabis businesses to date have historically been cash businesses. And the reason for that is that any federally insured bank cannot accept deposits from a cannabis business because cannabis remains a federally listed controlled substance. So from a funding
Yeah.
Right. From a funding perspective, there are options available. There are community banks, credit unions that are not federally insured, that are able to engage in lending to cannabis businesses. There are family offices and investment funds that again are able to engage in lending to cannabis businesses. If it is anything that is related to the federal government, they cannot.
I do want to say, folks, we are going to answer some of the local poignant questions around community boards. I'm going to ask one more thing from our Q&As, and then I'd really like for the Queen's Defenders to take some space up here. If someone has had possession arrests, but has had convictions expunged or dropped after community service, how will that be figured into the applications?
It will not figure into the applications negatively.
But will it figure it in positively?
Well, that's what I was going to get to. There is actually, as part of the social and economic equity program, a kind of, I'll call it super priority category, where there's extra priority given to applicants, and there are three categories that you have to hit. in order to fall into this special category. The first is that you're a member of a community disproportionately impacted by the enforcement of cannabis laws. The second is that you have an income lower than 80% of the median income in which you reside. And the third is that you've been convicted of a cannabis offense before the effective date of the MRTA, or had an immediate family member or guardian who is convicted of a cannabis offense prior to the effective date of the MRTA.
Thank you so much. And I just want to remind folks that you can play along by watching what the Office of Cannabis Management does every month. If you don't know, I put that link in the chat, but it is cannabis.ny.gov. And we do recommend that many of these questions will be answered in time, and we are still watching in real time as the Cannabis Board makes these decisions and the rules and regulations become more clear to all of us. So we encourage you all to watch the recorded monthly meetings, and I am going to kick it off to the Queen's Defenders and back to Tarika. Thank you all for all of your questions. We're going to try and get to more of them at the end of this.
Carolyn, the floor is yours.
So I will pass it to Manai so he could talk a little bit about the history, and then I will jump in with regard to expungement.
Thank you very much, guys. I appreciate the time. It's already been an education. We've learned quite a bit, and I will go into a little bit of some chronological history and background of marijuana now, or cannabis. Now, one of the things that we'll get into, and one of the problems that people like Curlin, myself, and other attorneys have, it's this big stigma that surrounds the plant. And there's a stigma that exists because it was forced onto the community, and then the community actually adopted that mindset. And because they did, there's this stigma against marijuana. So now that we're seeing dispensaries open up, we're seeing medical marijuana be embraced by the country, and we're seeing pressure put on the federal laws to change for marijuana. I think we're starting to get that this was all political, and it started off as political, and it still is. So I'll go into the history a little bit. I won't take too long of a time. It's a bit of a history lesson. However, it is a fun history lesson. So I will start by trying to share the screen. I hope I do this right. Can everyone see my screen right now?
You are good
Yes.
to go.
Do you mind,
Okay.
hi, you're good to go, but do you mind expanding your screen, please? So that it is in presentation mode? All the way in the top right.
Up right. Hold on a second.
Or even at the bottom, do you see the icons in the bottom right corner?
Just a second. Can someone jump on and do it? I'm not seeing what you're saying right now.
So in the bottom right corner, you'll see a plus and minus sign. To the
Yes, I
left,
do. I
to the
do.
left of the minus sign. To the left of the minus sign, you'll see an icon. No. To the left of the minus sign, you'll see an icon.
Okay.
Yes. So you'll click that. There you go.
Okay.
And then you
Beautiful.
can press the arrow. You can press the arrow button on your keyboard or on the.
Oh, thank you so much. That makes a lot of sense. All right. So we're much better now. So we're going to go into the history of a plant because, as we all know, everyone joining us, what we're discussing here is a plant. We've talked about processing, but nothing's processed. This is a natural plant, and it was from the beginning. So before the United States was founded, and while we were still a colony under the English rule, marijuana or hemp production was extremely strongly encouraged in America, or in the Americas, as it was then called. This is obviously pre-1789, when we became a country, pre-1776, before the Revolutionary War, pre-1789, before the country was formed. So early production of cannabis was done by American farmers. That's how they make money. domestic production of cannabis, once we actually became a country, flourished after the American Civil War. Hemp was used widely in the production of rope, sails, and clothing. Now, this was on or about the 1870s, right after the Civil War. Marijuana was still not frowned upon, and it was still not illegal. In fact, not only was marijuana not illegal, but in the late 19th century, between the 1870 and 1899, marijuana was used as a drug, for medicinal purposes in order to help people. As seen here, it was prescribed by doctors and had, as we're going to talk about soon again, as we know now, medicinal purposes, and you had marijuana medicinal patients way back as well. Now, little war south of America, the Mexican Revolution, happened, and what that forced was a big Mexican migration. It was a wave north of Mexican migrants. This is a picture right here of an all-female battalion that fought in the war. And this is what brought about the initial fight against not marijuana, but the people who smoked it and the people who would have it on them. The Mexican immigration and a convenient scapegoat was had. Mexicans who migrated after the war were heavily scapegoated because there were anti-immigrant sentiments all around. I'm sure there were some politicians around at the time saying that they're coming across our borders, they're rapists, and they're coming with marijuana. In fact, I'm pretty sure they were. And people fed off this anti-immigrant, anti-marijuana, and married them in order to have political successes, which they did. Moving right along, a little thing called the Great Depression happened in the late 1920s and continued almost throughout the 30s until the Second World War. And what happened was it accelerated an anti-immigrant feeling in the country, and also an anti-marijuana campaign that was already ongoing was stepped up. This was done in an effort to delegitimize not only the plant, but those who use the plant in the eyes of the people. What you see here is a picture from the Great Depression. It said, "Jobless men, keep going." And it's a little bit cut off, but it says, "We can take care of our own." And as some of you may know from history, the Great Depression was a very rough time. And it was also a time where a lot of ugliness and anti-immigrant and anti-Black sentiment was had. However, during the Great Depression, during this time, in the 1930s, marijuana was still legal. Cannabis was still legal and still widely used. We start to see by the early 30s a turn in the consensus of the country and what was being pushed. We see an era of reefer madness. For some of you guys who are a little bit older, you remember hearing about this at least, where there was fear and resentment of Mexican immigrants led to government efforts to make marijuana illegal. Now, this was done psychologically in many ways. There were TV programs, actually a TV movie called Reefer Madness. And it basically put forward, as you can see from this picture here, an anti-Black, anti-immigrant, fear the dark man with the white woman mentality in the minds of people. And this was done over time and psychological. Marijuana was called the devil's harvest, the smoke from hell. And marijuana was said to lead to debauchery, insanity, and all sort of vice. Now, after this mindset started to prevail more and more in the country, we started getting changes in the law. And the law started changing little by little. And on the federal level, the Marijuana Tax Act of 1937 made the plants illegal. Some of those who pushed this law were actually racist in disguise, legitimate racists masquerading as politicians and statesmen. Now, this is a quote here from Mr. Harry J. Aslinger, and I think it sums it up perfectly. It said, "Reefer makes darkies think they're as good as white men." And there is some truth in that ugliness, unfortunately, because this is the mindset of the people who passed the laws in 1937. Prior to 1937, however, marijuana or cannabis in the US, and when I say US, I'm speaking of federal laws, that was legal. This made it illegal, and then other states slowly followed suit. Cannabis, however, is a patriotic plant. And despite the stigma that was placed on it in order to delegitimize a certain group of the population, people realized that marijuana and cannabis was still good for the country. For example, during World War II, the US military launched a program that was called Hemp for Victory. Just a second, I'm sorry.
It's important to note that it's indigenous plant. Well, we see many plants coming in and are non-indigenous. This is an indigenous plant to Turtle Island.
Thank you. So during World War II, again, we had a Hemp for Victory campaign, and there were 375,000 acres of hemp in the US that was planted, and this was used and produced for parachutes and other important military gear. So our military was using the plant at a time when our politicians were stigmatizing the plant and those who used it. So when you see this again, it's all very political, and it's been historically very political as well. Okay, now, unfortunately, the anti-marijuana stance and the anti-Black stance came together, and the federal laws started to set mandatory sentences for marijuana, for having possession of marijuana. This started in the 1950s. And again, the PR against marijuana had started from the 30s, so the populace became, I don't want to use the word brainwash, but I'm trying to think of a better word. The populace became convinced that this plant was a bad thing. And that happened whereby the 50s, people were stepping up the mandatory sentences, and most of those people who were affected by these mandatory sentences were the poor or the quote unquote minority, the so-called minorities. Now, let's fast forward, and we're going to get into some alphabet here. We already have the MRTA, but reports commissioned by JFK and LBJ, two presidents that LBJ took office after he was JFK's vice president. They commissioned a report, and that report found that THC does not induce violence or lead to heavier drugs. Now, you're talking about two of the greatest presidents in the century commissioning a report that comes back and tells us the truth. However, this truth was not accepted. Only a few more slides to go. This is perhaps the most important slide. This is way back in 1972, and the Schaefer Commission, a federal commission that the President's Commission, stated that recommends that marijuana should be decriminalized for personal use. Now, this is back in 1972. 1972, as you know, the president back then was none other than Mr. Richard Milhouse Nixon, who was famous for using marijuana and other drugs to target groups of people he did not like. So President Nixon nixes the proposal that was made by the commission to decriminalize marijuana. And therefore, marijuana still to this day, 1972, if my math serves me right, about a half a decade, at least 50 years right now after the commission recommended decriminalization, on the federal level, as was stated earlier, we still have marijuana prohibition. That is Mr. Milhouse Nixon right there. Now, the 70s and Mr. Nixon was not kind to marijuana or cannabis. Unfortunately, what came the decade afterwards might, if anything, be even worse. The 80s, and I know I'm going back to a time when a lot of you guys only read about in history, but this was very big. And what the 80s brought is a former California governor who came to office, and his wife ran and led a campaign that stated just say no. And that was not only to hard drugs, that was to marijuana as well. And there was a very hard political stance against the plant. In fact, marijuana was not only not exempt from this all-out anti-drug 1980 stance by the Reagans. It was put up there as one of the main targets, and it was seen as a gateway drug. In California and other jurisdictions, there were 3 strike laws that impacted many who possessed marijuana. So there are many people who, because they received a sentence or a conviction for marijuana, along with other criminal sentences, they did quite a bit of time, as we know. Now, that was when it was really bad, but as they say as well, the darkest part of the night is just before daybreak. And daybreak is what we saw in the mid-90s with Prohibition 215. And Prohibition 215 was passed in 1996, and that allowed AIDS patients or patients suffering with HIV to have marijuana as for medicinal purposes as a drug. Now, again, way back at the start of this, we saw that people were using marijuana as a drug to heal themselves way back before it was decriminalized. And then after being decriminalized, we had to claw back our way first to get it legalized for patients, and hopefully, and then to get it decriminalized recreationally. Again, some of our old school people will recognize this slide. This is Sam Cooke, change is gonna come. And change did come for all of us, thankfully. It started with up 215, advances continue to be made. And then in New York, we had some very brave politicians who fought for MRTA and finally got it passed. Some of them had worked with us, some of them you guys here know as people. Ms. Stokes was mentioned earlier, who put their necks on the line in order to get this passed. And in the last year or so, we've had bail reform. We've also had raise the age. We've had marijuana reform, and starting in about a month, we're gonna have less is more for parole. So within the last year, there've been great victories had. Fighting for marijuana reform is a big one because, as Ms. Curlin will tell you, when she steps up here, many of our clients are pulled over. And the reason why they're pulled over, the reason that's given, is the smell of marijuana. Even though the police officers many times are unable to tell you if it's burnt or unburnt marijuana, because truly it's not really about what they smelled, it's about using the plant to get the stop. So this was a very brief and a very quick history of the plant, and how the most important thing here is the stigmatization that has happened. What was done was you decriminalize an entire population by decriminalizing a plant. And I think that people like these 3 people we're looking at right now realize that, and realize that there were things we had to do to change it. And MRTA is a big start. So I will hand it over now to Ms. Joseph and stop sharing. Thank you guys for listening to me.
Hey, hi, good afternoon. So I'm going to make it quick. So one of the most important things about MRTA for people who've been impacted by the policing methods where they arrested people, like you could have one joint and there were 5 people, they would arrest all 5 people. And so one of the big things with MRTA is expungement. Expungement means that the conviction comes off your record completely, meaning that no one can access it. The only person who would be able to access it would be the client or their legal representative. So some of the offenses that have been designated for expungement are criminal possession of marijuana as a violation. So the thing with that is a lot of people would plead to that because it was a lesser offense. But the thing with that is it was never sealed, right? So New York, prior to MRTA, sealed records. They did not expunge. The problem with sealing is that the NYPD still had access to those records, the DA's office still had access to those records, and even employers when looking to hire people, even though someone pled to a low-level offense like a violation, which is not even a crime, they would see that the person had that arrest and had, settled the case. And that would really harm your job prospects and sometimes even your housing prospects. So the offenses that qualified would be also, criminal possession in the 5th degree, which is out in public, which is what they would get the kids on all the time, and criminalize children and put them through the system for one joint. Also, too, we have some other offenses. Criminal possession of marijuana in the 4th degree, which is possession of more than 20 ounces, is also designated to be expunged. Also, criminal possession of marijuana in the 3rd degree and 2nd degree, as well as the sale of marijuana. So with expungement, meaning that now this comes off your record, you're not able to apply for housing because, especially with public housing, having a drug-related conviction sometimes led to being excluded from your home. It also is hugely important in that for immigration purposes, when a case is expunged, it's gone. So that means it's not a conviction. So in New York, you can answer the question and say, I have not been convicted of a crime. And you don't even have to acknowledge the arrest for New York State. But if you are dealing with the federal government, because as was pointed out before, it is still a federal crime. So if you apply for anything, including immigration, any job with the federal government, you still do have to disclose the arrest, because even though New York State removes the record, it still hangs out in the federal databases. One of the things that that would happen, as Manai could tell you as an attorney, a lot of times we would try to avoid our client having to make an admission to a marijuana-related offense because of the consequences, because especially with immigration. I know I've had clients who were deported for pleading guilty to a B misdemeanor, marijuana possession, open in public view. And that affected a lot of people. So that's why this legislation is so important, and especially the expungement part. The expungement is automatic. In other words, most people don't have to do anything for the expungement to occur. The DA's offices have reviewed their records, identified all the cases where people who were convicted of the designated offenses, they found them and they moved to dismiss. The statute gives, I think, up until March 31st of 2023 for the records to be dismissed. Now, things did go a little slower because of COVID. I mean, because obviously the goal is just to get this done as fast as possible. And I know that the Queens County District Attorney's Office, they went through their records, they flagged the cases, and they moved to dismiss. Also, if you have someone who was convicted of what was then a felony drug possession, and because of the new law, that was changed to a misdemeanor, the Department of Corrections, state and city were supposed to identify those people and move to have them released, since there's, what they were convicted of was no longer a felony crime resulting in jail time. I remember a case where someone had 7 pounds of marijuana and he lost a trial, got convicted, lost everything and went to state prison. And now he is someone who could be helped by this law. So also, as Manai mentioned, the police used to use the smell of marijuana as the pretext for illegal searches. So they say they smell marijuana, they pull up everybody in the car, take everybody out the car, search the car, search the trunk, search everything. Now, the smell of marijuana, it's made clear that that does not give a police officer probable cause to search your vehicle or to unfairly target you or illegally target you just because marijuana is being smoked. One of the important things too about the law is that, it is not encouraging the use of marijuana like while you're driving. So that it's unacceptable to drive under the influence. And that law was already on the books before MRTA, ever came along. Some quick caveats. So while the expungement is happening, meaning that these convictions are being vacated, there's something you should know, is that when someone pled guilty to a misdemeanor a few years ago, their DNA was collected. And so while MRTA gets rid of the conviction and it's gone, your DNA is still in the database. And you would have to consult with an attorney to make an application to remove your DNA from the database. Also, for people who are on parole or probation, neither department can use the fact that someone is using cannabis as a basis for a violation of parole or probation. You can still be drug tested, but they're looking for other drugs, not cannabis. And I think also too, the important, really quickly, immigration-wise, is the immigration court will not just accept like the expungement that the DA's office does. If a person has a case in immigration court, their attorney should file a motion before the court asking for the expungement, asking for a judge to order the expungement, because then that record could be used in immigration court to show that the person no longer has the conviction. For some reason, immigration court will not just accept when the district attorney of their own volition moves to vacate the plea. So that's the quick version of expungement. I think it's one of, New York was waiting a long time to get expungement, to try to make people whole so that now they can pursue business opportunities like those presented in MRTA. Are there any questions?
So we have quite a few questions, and I've sent Simone some of y'all's questions to prep him to try and condense this so that we do not extend everybody's night longer than we have to. Simone, take it away. Try and do what you can with what we got, and I'll manage your questions over here. And if you miss something, I'll remind you.
That sounds great. If we can, once I start going through this, save 5 to 10 minutes at the end for myself and Curlin and Monty to talk about kind of how we can help people advocate on the industry's behalf.
Yes, of course. And please add your information to the chat at the end and all of that.
Sounds good.
And if I can just jump in really quickly, when you're sharing your contact information, do you mind like reading out your telephone number, just because we have attendees that are joining by telephone and they probably can't see the screen or the chat?
Of course. So why don't we do that at the end, and I'll start going through some of the questions now.
Absolutely.
And I think one of the most important ones to talk about is how the community board process will work in New York City specifically. And this is a question that we get pretty regularly. And the answer is that as per the MRTA, as part of any retail or on-site consumption license, the applicant is required to notify their community board, and their being the community board that governs the location where they're planning on operating as part of the application, that an application is going to be submitted, specifically so that the community board has the opportunity to submit their opinion in writing to the Office of Cannabis Management and the Cannabis Control Board on whether or not the applicant should be issued a license. Now, it's important to note that the community board cannot prevent you from getting a license. So simply by saying that they're not in favor of a license being issued, which is particularly relevant in New York City, where there have not been opt-outs, but there are obviously community boards that are less in favor of the industry, which is something that we'll talk about. But the letter from the community board is something that is going to be considered as part of the application process. So you do have to notify them, and they do have the opportunity to submit something in writing to the Office of Cannabis Management. We saw a couple of questions about how community is disproportionately impacted by the, I'll call it war on drugs, is defined. there is a definition. It is not a conclusive definition in the MRTA, but basically for any municipal region, zip code, area code, town, village, what is done is the kind of history of arrests and convictions for cannabis offenses is compared to surrounding areas. That's kind of loosely how they will define disproportionately impacted. It is something that is going to be more clearly defined as part of the rules and regulations. I'm just going to run through these. So in terms of developing an app to connect retailers with adult users, what type of license would I need? The answer is right now, one, we don't know. And two, this doesn't neatly fit in the definition of any specific license type. The MRTA has very express language about what sort of marketing is permissible. And this is something that really is going to need to be fleshed out once rules and regulations come out. You know, if you have been to any other state in which there are adult use dispensaries operating, obviously there is an online component to it where you can order in advance, but you have to pay at the location. All of this is something that's going to have to be fleshed out once the rules and regulations come out. So no specific answer to what license type. In terms of prioritizing cultivation micro business licenses before the other license types, I think this is a fantastic question. This is something that a lot of us have been kind of grappling with. The answer is that there have been rumblings, and I believe Senator Cooney is one of the people who's openly spoken about the importance of having cultivation licenses, including micro business, issued before retail. Definitively, we don't have an answer to that question. I certainly hope so. The best chance that we have for the industry to hit the ground running is if we have enough supply to meet demand. And I think everyone who's participating in this knows that there's significant demand. That's going to be kind of tenfold once we're operating legally. Will delivery businesses only be able to deliver from dispensaries, or will they be able to have their own inventory? The short answer to this is we expect that you'll need to have a separate license and that you will only be able to operate as an intermediary between retail dispensaries and consumers, which means that you would not be able to have your own inventory. Part of that is that the MRTA is very clear that while there is some overlap in very limited circumstances for different license types that's permitted, one of the black line rules is that you cannot have an interest in a retail dispensary license and any other license type, which would seem to indicate that that would apply to delivery licenses as well. Obviously, the caveat is we haven't seen the rules and regulations yet, but I expect that the answer will be that delivery licensees will be responsible for solely delivering product from retail dispensaries and not having their own inventory. Does anyone know anything about home cultivation for medical patients? The answer is yes. It has been expanded. I believe, I have to quickly take a look, that the expansion has gone into effect already. But I will circle back on the specific answer to that. With respect to keeping plants for non-licensed medical patients or non-medical patients, the answer is that right now you cannot grow at home because the rules and regulations haven't been issued. And so I know that that's a bit of a frustrating answer because a lot of this seems like it's kind of totally gray area right now. You are allowed to legally possess and consume, but you're not allowed to legally buy, which makes kind of difficult to wrap your head around, because how are you supposed to consume something that you're not able to buy? You're not allowed to grow, but you're able to consume. It's all kind of somewhat complicated right now, and all really a bunch of gray areas. But the short answer is, right now you cannot cultivate at home.
Simone, can I have Mani answer there's a two-part question. There's one about probation or parole and using marijuana against you. And also it was a question combined with cultivating. So could you answer that for us, Mani?
As far as parole, that's one of the things I'm a little bit of an expert on. And with less is more, which will start on March 1st, parolees will not go to jail anymore for what's called technical violations. And that's not just marijuana, that's any drug test at all, any curfews, things that they used to lock you up for, they won't be able to do. It's my understanding that in probation as well, marijuana is not something they can use against you because it's legal. So that's my understanding from the clients I've spoken to and the parole officers I've spoken to.
And may I also follow up with how long does it take to get a record expunged?
That with the law, it happens automatically. So it's not a situation where you have to go in and actually do it. But if you want to speak with an attorney, or if you want to ask any specific questions about your specific case, I'm sure both Ms. Joseph and I would be happy to look into that for you as well.
Simone, did you want to jump back, or do you need more questions? Did you go through everything I sent?
One question I did want to answer, which was, how will being a minority-owned business be helpful, and how will it be validated if we're starting a new company for cannabis? So how it will be helpful is in some part kind of a numbers game. So there's going to be priority given to social and economic equity applicants. And part of that is that there is this target goal of 50% of licenses being awarded. And when you look at the MRTA in the text of the legislation, whether or not you're a social and economic equity applicant is really the first thing that's listed as part of what needs to be included as part of your application. And so there has been really like a push to make sure that potential equity applicants are aware of the MRTA, and that there are going to be resources available. And so again, we don't know the specifics of it, but I think it's pretty clear based on both the spirit and the actual text of the MRTA that priority is going to be given for equity applicants. In terms of validating if you're starting a new company for cannabis, so there isn't anything in the text of the legislation that talks about kind of being a certified minority-owned business. That's not expressly a requirement as of yet, but you know, it's something that we may see when the rules and regulations come out. But I think kind of the bigger picture view on this to kind of keep in mind is that the Office of Cannabis Management, the industry as a whole, really wants the people who've been given less opportunities in this industry historically to have an opportunity to get in. And so the goal here is not to kind of create additional roadblocks for people to apply and to get licensed. And so really technical requirements that are time consuming and costly, we don't really expect to see in the rules and regulations.
I did want to follow up with, do we know the definition of communities disproportionately affected?
We do. I thought I covered that, but the definition is both specific and vague. It's arrests, convictions in a specific geographic area, be a zip code, area code, municipality, community board, versus kind of surrounding areas. And then the real true kind of how do you define it in comparison's sake, we'll see in the rules and regs. But there is a very open-ended definition within the MRTA.
Okay, great. I think you may have answered this, but I just want to make sure that we're getting to all of this because it's heavy out there and folks are really engaged. And I really do appreciate everyone for being engaged. This is literally a lifelong dream for me to be doing this from the Queensborough President's office, as much as you can tell from the smile on my face. About ballpark, do you know what the dispensary license cost and the need for lawyer fees, et cetera, would be?
The short answer is, unfortunately, as of now, we don't really have a ballpark. I can say historically that in other states, it really depends on how intensive the license process has been and what the specific fees are from a license fee perspective. I mean, that's just going to be what the rules and regulations say they are. From an attorney's fees perspective for the license process, for really intensive applications that involve, really compiling the application and coordinating everything and negotiating all of the various contracts and all of that, in really complicated, heavily regulated states, attorney's fees run anywhere from $20,000 to $200,000. And again, the important thing to note in that circumstances is that in other jurisdictions, many times vertical integration is allowed, so it's a more comprehensive process. In New York specifically, we don't really quite yet have a great handle on what the ballpark overall attorney's fees will be. And this is a conversation that we have with clients on a regular basis. So it's one that I'm very comfortable having. Until we see the rules and regulations and really have a definitive idea of how involved the application process is going to be, we just won't know. The other variable is really how much guidance the specific client needs, right? I mean, there are different parts of this. There's buying or purchasing real estate. There's making sure that the insurance provisions are correct. If you will need insurance in whatever you do, there is a labor I think it's a union requirement. A labor peace agreement for any cannabis business under the MRTA. And so there are a lot of different things that go into it. And until we see the rules and regs, really having a clear answer on what overall fees are will be hard to give.
There's quite a bit still going on here. There's a question with regard to if I fall into the category of making less than 80% of the mean income in my area, does that make me a social equity applicant? And also, does being on disability give any qualification for social equity?
So the falling into the income of less than 80% of the median income in and of itself does not qualify for social and economic equity applicant. As I mentioned, there's that super priority. It is and, which is that you fall into that income category, that you're in a community that has been disproportionately affected by cannabis arrests and convictions, and that you have been arrested for cannabis possession or someone in your immediate family or guardian has. So that in and of itself, from an income perspective, does not qualify you. What was the second half of the question?
It was with regard to disability. I think that your answer answered.
Okay.
May I kick it to you, because you have been answering some stuff in the chat, and I feel like if you go live, if you turn on your mic and answer some of these questions you're ready for, please go ahead.
Sure. I think one of them was about medical patients, if I'm not mistaken.
Yeah, there's a lot of questions around medical cultivation. You did answer that. I put it in the chat, but please address that, and then I'll read the other question from a Q&A for you live if you like.
All right, just for you guys to know, medical marijuana has been around in New York now for quite a few years. I personally know people who've been patients now since 2017. And who've been renewed. I believe you have to renew your card every single year also. And for those people, the way the law was written, at least to my reading, was that 6 months after the law went into effect, which was March 30, 2021, medical patients would have the right to grow plants in their home. There was a little bit of question about whether or not they were ready for that, but to my knowledge now, it's allowed to grow if you have a medical marijuana card. If you do not have one, I believe the regulations would say it's 18 months after the dispensaries begin to sell. So the wait is going to be a little bit longer. But as far as the medical patients, if you are a patient, you're allowed to now grow plants in your house.
Yes, I believe you're correct. Also, that is what I've heard, and I've also seen. Can confirm. We'll read aloud another question for you that I believe you're ready to answer. Does anyone know anything about home? We did that one. Just heard that if you are on probation or parole, they cannot use the use of marijuana against you anymore. Did I hear that right?
Yes, that is correct. And again, for some of these questions and people who have individual questions about themselves, you could reach out. We could go a little deeper. But yes, that is correct. That's a big change for people who were forced to basically do urine tests. And this affected, for us, especially our clients who just came out, because those are the guys that they would test, the guys just going on probation, or who just came out on parole, because that's when you're more likely than not to make a mistake. But now that is no longer a mistake because it's legal. So this is no longer an illegal product. So other drugs, no. But as far as cannabis is concerned, you should be in the clear. And if you have any questions or problems with your parole officer or probation officer, feel free to reach out.
I can jump in on that real quick too, because the only exception is if they make it a special condition of your release. And that's the only exception. And so the special condition can only be considered in cases where it's shown by clear and convincing evidence that the prohibition is reasonably related to the underlying crime. So if they're able to meet that burden, they can impose a special condition on a parolee that he or she not use marijuana. But other than that, you should no longer be punished or incarcerated for the use of cannabis.
I did want to follow up. I know that we've covered community, but this seemed like a relevant question. And I do know that the law has recently changed about honorable discharge from military service. A friend of mine worked on that case. So it says, please define community, geographical area, or specific group, i.e. veterans and minority. So do we want to address whether or not veterans that were disproportionately affected in this time? Does anybody know the answer? Will the MRTA process that? Because I believe it passed before the veterans got that right.
One of the categories for equity applicants is service disabled veterans. That was in the original version of the legislation.
Great, thanks. I think we're 1 minute before. I spoke too soon. It's 7 o'clock. I know that there's a plethora of questions. I do like to run a fairly tight ship, as most of the folks do over here at Borough Hall. And so if we weren't able to get to your questions, this isn't the last time. We will be working on this. I do want to be thoughtful and mindful of those of us who do have children and families and whatever other arrangements that they have. I'm so appreciative of everyone for all of their engagement and all of everybody's questions. Please do follow up with our office. Those emails have been shared in the chat. Tiffany Eason, Tarika Morrison, and mine as well, Catherine Bresler. Thank you all for showing up. Tarika, if you have any further comments, please.
No, I do not. Thank you all. As Kat said, we'll be continuing to do this work. So please look out and reach out to us. If you have any questions, we are happy to assist you and connect you with whomever you need, whether it be licensing, whether you need help sealing or expunging your record and have any questions around that. So please continue to connect with us, and we hope to hear from you soon. And thank you to our panelists. Thank you so much. You gave us a wealth of knowledge this evening. So thank you, thank you, thank you.
We loved the history lesson. Please give it to all of our community boards next.
Brilliant, will do. Thank you so much, guys. It was a pleasure.